How legal rules evolve. We now consider a sequence of cases in order to apply the preceding ideas and show how law evolves. The three cases come from England and concern tort law, which covers accidents. Butterfield versus Forrester, 11 East 60, open parentheses, capital K dot capital B dot 1809 superscript 13, which reads: Our selection and discussion of these cases owes a great debt to the stimulating lectures given by Professor Robert Summers to the Fifth Legal Institute for Economists. This was an action on the case for obstructing a highway by means of which obstruction the plaintiff who was riding along the road was thrown down with his horse and injured, etc. Superscript 14, which reads: The phrase action on the case refers to an old legal category of dispute. Simply read it as dispute. At the trial before Bailey J. at Derby, it appears that the defendant, for the purpose of making some repairs to his house, which was close by the roadside at one end of the town, had to put up a pole across part of the road, a free passage being left by another branch or street in the same direction. Superscript 15, which reads: J means judge or justice, and by tradition, opinions are headed by the last name of the judge or justice who wrote the opinion. That, back to the text, that the plaintiff left a public house, a tavern, not far distant from the place in question at 8 o'clock in the evening in August, when they were just beginning to light candles. But while there was light enough left to discern the obstruction at 100 yards distance, and the witness who proved this said that if the plaintiff had not been riding very hard, he might have observed and avoided it. The plaintiff, however, who was riding violently, did not observe it, but rode against it, and fell with his horse and was much hurt in consequence of the accident. There was no evidence of his being intoxicated at the time. On this evidence, uh, Bailey judge directed the jury that if a person riding with reasonable and ordinary care could have seen and avoided the obstruction, and if they were satisfied that the plaintiff was riding along the street extremely hard and without ordinary care, they should find a verdict for the defendant, which they accordingly did. Question 3.1. There's four parts: A, B, C, and D. A. Who is the plaintiff? What is he asking the court to do? B. Is there a statute involved in this dispute? C. Who won? D. Was the jury asked to determine fact or law? How was the law stated? When this case was tried, English law accepted the principle that a defendant whose negligence caused the plaintiff's injury would be held liable. Consequently, the judge instructed the jury that the defendant should be held liable if he could have avoided the accident by taking reasonable care. This case presented a novel issue. Suppose that the defendant was negligent, but further suppose that the victim was also negligent. Should the defendant still be held liable for the victim's losses? An excerpt from the opinion of the judge in this appeal follows. Lord Ellenborough, C.J. which I presume is judge. A party is not to cast himself upon an obstruction which had been made by the fault of another, and avail himself of it, if he does not himself use common and ordinary caution to be in the right. In case of persons riding upon what is considered to be the wrong side of the road, that would not authorize another purposely to ride up against them. One person being in fault will not dispense with another's using ordinary care for himself. Two things must occur to support this action: an obstruction in the road by the fault of the defendant, and no want of ordinary care to avoid it on the part of the plaintiff. Contributory negligence is a complete bar to recovery. Question 3.2. There are three: A, B, and C. A. Who appealed the judgment? B. Who won the appeal? C. What is the judge's holding? When precedent does not provide a clear rule for resolving a dispute, the judges must create such a rule. Novel disputes are the occasion for altering the law made by judges. Lord Ellenborough created a new precedent. In this case, how broad is the new precedent? Under a narrow interpretation, the judge held that riders of horses cannot recover money damages for their injuries from a negligent defendant if they do not ride with ordinary care, and this lack of care contributes to the accident. This narrow interpretation says that the rule applies only to accidents like this one. Indeed, Lord Ellenborough's example of a horseman riding on the wrong side of the road into another's horseman riding on the correct side of the road would seem to support this narrow interpretation. But a broader interpretation of the court's holding is possible, and in fact, come to be the common interpretation. Under a broad interpretation of the holding, Lord Ellenborough held that no plaintiffs can recover when their own negligence contributes to their injury, even if the defendant was negligent. This was new law. About 30 years later, another novel case arose involving similar facts. Davies versus Mann, 10, capital M and capital W, 545, open parentheses, capital E, capital X, dot, comma, year presumably 1842, close parentheses, superscript 16, which reads, the traditional English court system that took shape in the late 12th century and prevailed until the late 19th century consisted of three common law courts and a court of equity. The first of the common law courts was the Court of Common Pleas. The members of that court were called justices and were presided over by the Chief Justice. The court originally concentrated on civil disputes concerning land, but came to consider a wider range of civil disputes. The Court of King's Bench and Second Common Law Court was originally a criminal court, but over time became a court of review over the civil issues appealed from the Court of Common Pleas. The third common law court was the Court of Exchequer of Pleas, or more simply, the Court of Exchequer. The Exchequer was the king's treasury. This court originally heard disputes arising from tax liability and other matters concerning the king's revenues. In the late 16th century, the Court of Exchequer had extended its jurisdiction to cover nearly all civil disputes. Members of that court in which the appeal in Davies versus Mann was heard were called Baron, abbreviated capital B, and were presided over by the Chief Baron, abbreviated capital C dot capital B dot. The equity court was the court of chancery, so called because it was presided over by the chancellor, the most important member of the King's Council. England established this court by the late 15th century as a separate court specializing in the dispensing of a more flexible kind of justice than that available in the so called law courts, especially with respect to remedies. There is therefore a great historical and substantive difference between the courts of law and the court of equity. One of the most important of those differences has to do with the types of remedies available to a successful plaintiff. Roughly speaking, a court of law would award only compensatory money damages, an amount that would compensate the plaintiff for his injury. A court of equity would possibly do more than that if the plaintiff could demonstrate that his injuries were such that a payment of money damages would inevitably undercompensate him. Continued in the Act of 1873 and the Supreme Court of Judicature Consolidation Act of 1925, the British Parliament replaced all of those courts and the distinction between law and equity with a greatly simplified structure that drew no distinction between common law and equity. As we shall see in Chapter 4, these dusty historical matters are relevant to one of the most famous examples of law and economics, the Calabresi and Milliman argument regarding the most efficient method of protecting illegal entitlement. Back to the text. At the trial before uh, Erskine J. Judge, it appeared that the plaintiff, having fettered the 4 feet of an ass belonging to him, turned it into a public highway, and at the same time in question, the ass was grazing on the off side of the road, about 8 yards wide, when the defendant's wagon, with a team of 3 horses, coming down a slight descent at what the witness termed a smartish pace, ran against the grass, knocked it down, and the wheels passing over it, it died soon after. The learned judge told the jury that if they thought that the accident might have been avoided by the exercise of ordinary care on the part of the driver to find for the plaintiff, the jury found the verdict for the plaintiff. Bonson now moved for a new trial on the ground of misdirection. That is, the defendant's lawyer appealed the judgment on the ground that the judge in the trial court had incorrectly instructed the jury on the law to be applied to the facts in this case. The act of the plaintiff in turning the donkey into the public highway was an illegal one, and as the injury arose principally from that act, the plaintiff was not entitled to compensation for that injury, which but for his own unlawful act would never have occurred. The principle of law, as deducible from the cases, is that where an accident is a result of faults on both sides, neither party can maintain an action. Thus, in Butterfield versus Forrester, 11 East 60, it was held that one who is injured by an obstruction on a highway against which he fell cannot maintain an action if it appear that he was riding with great violence and want of ordinary care, without which he might have seen and avoided the obstruction. Lord Abinger, capital C, dot, capital B, dot, which means, what was it, Chief Baron? Yep. As the defendant might, by proper care, have avoided injuring the animal and did not, he is liable for the consequences of his negligence, though the animal may have been improperly there. Park, um, capital B dot, which is barren. The negligence, which is to preclude a plaintiff from recovering in an action of this nature, must be such as that he could, by ordinary care, have avoided the consequences of the defendant's negligence. Although the ass may have been wrongfully there, still the defendant was bound to go along the road at such a pace as would be likely to prevent mischief. Were this not so, a man might justify the driving over goods left on the public highway, or even over a man lying asleep there, or the purposely running against a carriage going on the wrong side of the road. Open bracket, new trial denied, close bracket. Question 3.3. And there's three questions A, B, and C. A, who appealed the judgment? B, who won the appeal? C, what is the judge's holding? Actually, there are three opinions. Are they in accord? The plaintiff has suffered a loss. His donkey was killed, allegedly because the defendant was driving a wagon too quickly for the conditions on the road. However, the plaintiff himself was negligent for having left his donkey unattended, although fettered beside a public road. Strictly following the rule in Butterfield, the plaintiff's fault or negligence contributed to his losses and thus should bar his recovery. That is precisely what Mann's lawyer argued in appealing the judgment for the plaintiff in the lower court. But at the trial, the court believed that the facts in Davies versus Mann were distinguishable from those in earlier cases in which a contributory negligent plaintiff was not allowed to recover from a negligent defendant. There appear to be two reasons for excusing the plaintiff's negligence in Lord Abinger's and Baron Park's opinions. First, there is the element of time. Although the plaintiff was negligent in leaving his donkey unattended on the public highway, the defendant's negligence came afterward. And if the defendant had not been driving recklessly, he would not have had time to avoid he would have had time to avoid the donkey by stopping or swerving, even though the donkey ought not to have been unattended where he was. Apparently, the defendant's negligence came afterward and controlled the outcome. This doctrine has come to be known as the last clear chance rule. If both parties to an accident are negligent, the party who had the last clear chance to avoid the accident will be held responsible for losses arising from the accident. The second argument for excusing the plaintiff's negligence is to encourage precautions in the future by people situated like the defendant, Again, Baron Park puts the point nicely. Although the ass may have been wrongfully there, still the defendant was bound to go along the road at such a pace as would be likely to prevent mischief. Were this not so, a man might justify the driving over goods left on a public highway, or even over a man lying asleep there, or the purposely running against a carriage going on the wrong side of the road. This interpretation of the law suggests that rules should create incentives for avoiding accidents. Notice that Davies versus Mann changes the law handed down in Butterfield versus Forrester. The blanket rule from the earlier case, contributory negligence, is a complete bar to recovery, was amended by judges who faced a new situation. We may say that after Davies versus Mann, the legal rule became contributory negligence is a complete bar to recovery unless the defendant had the last clear chance to avoid the accident and did not take that chance. The last clear chance doctrine was quickly adopted throughout the common law world. Superscript 17, which reads, but that is not the end of the story of contributory negligence and last clear chance. For a fascinating further episode, see British Columbia Electric Rail Company Limited versus Loach. Open bracket 1916 close bracket 1 capital A dot capital C dot 719. In brief, here is what was at dispute in that case. Benjamin Sands was driving a horse drawn wagon and talking with a friend, not paying attention to his surroundings. He pulled onto the train tracks and stopped. He looked up to see a train coming. The train's engineer applied the brakes as soon as he saw Sands and his wagon on the tracks. Unfortunately, the brakes, unknown to the engineer, were defective and failed to stop the train before it ran into and killed Mr. Sands. Loach, the executor of Sands' estate, sued the British Columbia Electric Rail Company on a theory of negligence. The railroad claimed, following Butterfield, that it should not be held liable because Sands was contributorily negligent. Loach answered that the railroad had, following Davies, the last clear chance to avoid the injury and did not take that chance. The railroad claimed that it had not, in fact, had the last clear chance because its brakes were defective. Everyone agreed that the train would have stopped in time had the brakes been in good working order, and that the railroad should have checked the brakes before leaving the roundhouse that morning. The holding was that the railroad should be held liable. To hold otherwise would, the court said, create an incentive not to maintain one's train or car or wagon or other device in good working order. Conclusion. To summarize, we compared the two great league traditions, the civil law, and the common law. We examined the hierarchical structure of U.S. courts. We saw some of the general characteristics of a legal dispute. A plaintiff who alleges that he or she has been wronged by a defendant and seeks the court's help in getting relief. We learned some methods that judges use to resolve novel issues. Finally, we looked at the evolution of the doctrine of contributory negligence as developed by courts. This chapter provides a brief, selective introduction to some of the basic facts about law, which we analyze using economics in the rest of this book. Suggested readings: Berman, Harold J. and William R. Greiner, The Nature and Functions of Law, 4th edition, 1980. Cardozo, Benjamin, The Nature of the Judicial Process, 1921. Einsberg, Melvin A., The Nature of the Common Law, 1989. Franklin, Mark A., The Biography of a Legal Dispute, An Introduction to American Civil Procedure, 1968. Levi Howard W. and Introduction to Legal Reasoning, 1949. Merriman, John H. The Civil Law Tradition, An Introduction to the Legal System of Western Europe and Latin America, 2nd edition, 1985.